Hello everyone. Today we're going to talk about the judicial process of health information. So health records do have many purposes. So one, to help with direct patient care because the healthcare professionals, the doctors, the nurses, need to have an understanding of the patient's past medical history and what they're currently being treated with, right? So that they can give them the best care. To help improve quality of care, for public health monitoring, billing and reimbursement, which is where medical coding comes into play, and as a legal document to make sure, the correct standard of care was met. In order to disclose a patient's health information, so their health records, you have to either have permission from the patient or there has to be a legal mandate. So this chapter is going to talk about all of the situations that use the legal process to disclose health information. So we've already gone over evidence a bit. We all know that's what's used to prove or disprove something. It can be in the form of written or recorded testimony. It can be objects and things or health records. So before a party can use the health record as evidence, they have to determine if it's admissible. So what they're asking is it pertinent and is it proper? This question is governed by the rules of evidence that I talked about before. And for health records, the rule of evidence we use is called the hearsay rule. Okay, hearsay is defined as out-of-court statements that are offered to prove the truth. So the reason that health records are considered hearsay evidence is because the healthcare providers that are making the statement, so the doctor that's making an entry in the patient's chart, they're not doing so in court under oath. Okay, so since they're considered hearsay evidence, they are subject to the hearsay rule and are not allowed as evidence. Of course, there are a few exceptions. In order to use an exception, the side wanting to admit the health record has to meet the foundation and trustworthiness requirements. So a foundation is made by proving that the record was made and kept in the ordinary course of business at or near the time of event, so it can't be written in weeks later, and by a person with knowledge of the acts, events, conditions, diagnoses, whatever, appearing in it. So it has to be someone that was there. After meeting that foundation requirement, they have to prove the accuracy and trustworthiness by presenting the custodian of records, aka the health information professional, and they have to explain what the record-keeping procedures are. So the health information manager can be called to testify to prove that foundation and trustworthiness requirement. In order to do this, they have to know, what are the requirements for creating and maintaining records? Is it in accordance with any government or accrediting agencies? If so, which ones? They have to know the internal policies and procedures that talk about who has access to the records, what quality control methods are used, what's the approved way to make any corrections in the record, what abbreviations are okay to use. And if electronic records are involved, there are even more steps to establish the foundation and trustworthy requirements, but we'll actually talk about that in a different chapter. So typically the health information professional will testify either at a deposition or the actual trial. As we already all know and remember from last chapter, in either situation, they will be placed under oath and answer a series of questions to establish the foundation and trustworthiness requirements. If they're given a subpoena duces tecum, they would have to bring a copy of the health record. Okay, some of the things they could be asked, for a full and complete search for all records, if that was done, for a copy of the record, to be accurate and complete, if all entries were made in the ordinary course of business, and then what procedures are followed to ensure the accuracy. Kind of already touched on that. So on top of overcoming the hearsay rule, if one side wants to use the health record, they have to also overcome the privilege doctrine. So privilege, that's the legal right to keep certain information confidential and protect it from subpoena or discovery or being used in trial. This requirement can be waived if the party that has the privilege, so the party whose health record it is, discloses the protected information, whether by accident or intentionally. Okay, so if they accidentally release this information, like in a discovery request, then the other side can then use it in the trial. Okay, physician-patient privilege is the most commonly used privilege. So it was created by a statute and is used to keep providers from being forced to talk about information they get while treating a patient. It exists so, the patient feels comfortable enough to be open with their provider and tell all of their ailments, or whatever, no matter how embarrassing. Because if you thought your doctor could legally tell anyone and everyone stuff about your problems or your treatments, you probably wouldn't want to tell them everything, right? So really, it's the patient that has the privilege. Okay, the provider can just use that privilege so that they aren't forced to talk about the information. Okay, there's also attorney-client privilege, which protects whatever a client tells their attorney in confidence while trying to get legal advice, and work product privilege or work product doctrine. This covers any materials that are prepared, before a lawsuit that can be kept from discovery. Okay, so like with privilege, there are also exclusions to prevent the admission of evidence in court cases. One of these exclusions is if the healthcare provider apologizes for an unanticipated outcome. So this can be like a sympathetic statement, like, I'm sorry this happened, or admitting responsibility, or both. Some states have laws now that prevent the apology from being admitted into evidence in medical malpractice. So if the doctor apologizes, they can't use that in court, like, he said he was sorry, so he must be at fault. Because generally, if the providers apologize in a timely manner, there are fewer lawsuits. So they're trying to make it to where doctors can apologize and it not be held against them. Okay, the general rule is that the healthcare provider has ownership over the health record, okay, the medium in which information is stored, with limited property interests owned by the patient. Okay, so the doctor or the hospital owns the health record. Okay, you have a right to the health information, your own health information, but the doctor owns the physical record. Because of this, the provider is responsible for taking care of that record, and it can only be removed from their care with certain legal processes, like an authorization from the patient, a subpoena, court order, discovery request, or a warrant. Okay. The most common legal process a healthcare provider will encounter is being served with a subpoena. So this is a command used by a court or authorized official to appear and give testimony. It's called a subpoena ad testificandum. There's also subpoena duces tecum, I mentioned already. Very similar, but you have to come and present specific documents or things that were written in the subpoena duces tecum. This is not the same thing as a court order. We'll talk about that in a minute. Okay, there are certain elements that are common to all valid subpoenas. So it has to have the name of the court, the parties, the docket number, the date, time, place of appearance, what documents are to be produced, the name and phone number of the requesting attorney, signature or seal of the official empowered to issue it, and any witness fees if it's provided by law. Okay, and this is an example of what a subpoena looks like. So this image is also in your ebook, so you can either pause this or check that out on your own later. Okay, so a court order allows someone to disclose patient-specific health information that would typically not be allowed by statute or regulation. Okay, a subpoena cannot do this. Subpoenas are subject to all of those legal defenses created by statute, regulation, and common law, like privilege, like I mentioned. Okay, so a court order is above that. A show cause order is just a little different. It's a court decree telling someone to appear in court and explain why the court shouldn't take a proposed action. So in relation to health information, they would use this type of court order if the health information professional doesn't respond to the subpoena. Okay, so if the person doesn't persuade them to not take action, or or just doesn't respond, then the court will take the action that was originally proposed. Okay. We already talked about discovery last week in chapter 2, so this slide's just a refresher. We should all remember a deposition is a testimony under oath before a trial. An interrogatory is written questions that are answered under oath before a trial. Important for health information professionals is a request for production of documents and things. This is, inspecting or copying documents or other physical evidence by written request. A physical or medical exam can be court ordered if there's reasoning for it, and requests for admissions are the written questions to get someone to admit to a specific thing. Same thing here, a recap of electronically stored information. The Federal Rules of Civil Procedure in 2006 revised the rules to include ESI. So that would be emails, web pages, Word files, flash drives, electronic health records, etc. So this is called e-discovery as opposed to discovery. All right, moving on to warrants, which is a court-approved ability to search and seize property or information. Law enforcement has to present to a judge specific details about the property or the information that they want to search and what their reasoning for wanting to do so is. If they have enough probable cause or reason to believe a crime has been or will be committed, then the judge will issue a warrant. Oops, sorry guys, I was on the wrong slide. Okay, the warrant has to be carried out in a certain time frame. Typically, law enforcement has to announce themselves and execute the warrant during the daytime, unless it's specifies as otherwise. They have to inventory and describe in writing all of the items they want to seize, and they're supposed to give a receipt to the suspect for what was taken. For a no-knock warrant, law enforcement does not have to announce themselves. This is usually only granted if they have a reason to believe that the suspect will either destroy evidence or if the police officers might be in danger. Okay. Now, the law allows police to search without a warrant if it's time sensitive or if it's an emergency. Plain view doctrine is kind of along the same lines. It allows police to search without a warrant if they can see some sort of evidence from the window or the door or something like that. It's in plain view, right? So they don't have to wait for a warrant for something like that, because by the time they would leave and come back, the suspect would have probably gotten rid of it. Okay. So before they ever get a subpoena or a court order, the health information manager should have a litigation response plan in place that lays out everything they need to do in the event they do receive a request. Okay. They can and should ask for guidance from their facility's legal counsel and other members of the healthcare team. Okay, where e-discovery is concerned, remember that electronic, all the word pages, flash drives, stuff like that, it's best to create a legal response team that would include the legal counsel, senior leadership, health information management, and information technology professionals. So this team would work together to clarify the components of the ESI, talk about the cost, the storage, and production of ESI, and then how they would go about searching and maintaining it. All right, so just because you receive a discovery request or a subpoena doesn't mean that you should automatically release all of the information requested. Because if you do so, and you should not have, then the provider can be held liable. Because remember, they're responsible for the health record, and it would be your fault. Okay, so to figure out if the information should be released, you first have to figure out, does this require the patient's written consent? Next, is the information subject to privilege? Okay, are those requirements there? Also, any health information, this is important, any health information regarding substance abuse, mental health, or AIDS or HIV treatment, all require a written release of information from the patient that specifies this information can be released. Okay, it can't be just a general release of information form. The patient has to specify that this stuff can be released. Okay. So if you're in a situation where you feel that you can't release this information because of one of those things, you should definitely check with legal counsel. They could even file a motion to quash the request or get it dismissed. But if the motion is denied, then you do have to release the information. They could also try to get the patient to sign a release form specific to the sensitive information. And if all else fails, you can release the health record, but with the sensitive information excised or removed or, blacked out or something like that. If you do it that way, then you would need to inform the requesting side, the attorney, that we complied with the discovery request in part, and that the non-released information cannot be released without a court order or valid consent from the patient. Okay, now, if the request is valid, the health information professional would then begin the certification process, where they have to verify that the copy they're providing is an exact duplicate of the original. They usually do this with a written certification letter. And, you should never just ignore a discovery request or a subpoena or court order. This would be bad. You can be fined. You can be held in contempt of court. And I don't think the hospital, healthcare facility you work at would, look kindly on you for that. So, okay, that's it for chapter 3. Let me know if you have any questions. Hope y'all have a good week.